Hello, and a warm welcome to the EDRM Global Webinar Channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is a collaboration with EDRM trusted partner, eDiscovery Today, and it's in its 5th season. It's called Most Important eDiscovery Case Law Decisions for May of 2025 with our faculty experts, Doug Austin, Tom O'Connor, the Honorable Judge Andrew Peck, and myself. We welcome your questions and feedback in the console. Questions will be answered during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. And slides will be available afterward as well. Kaylee Wallstead, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available, Kaylee?
As long as you can hear me, Mary.
I definitely can hear you, Kaylee.
Well, that's good news. So we're loving on 24 with so many more ways for you, our audience, to engage, and we hope you're loving it too. If you check out your console to the right of the screen, you'll see the question mark icon. And if you click on it, this is where you can type in your questions for today's faculty. And we highly encourage you to do so. There's a paperclip icon, and if you click on that, it's for related content. And we have curated some great content for you. On 24, engagement tools descriptor for you to download to help you better engage with the platform. There's a link to click to subscribe to eDiscovery Today blog, and never miss a thing. If you are not subscribed, you must subscribe. It's my favorite way to start the day, and I know so many others who enjoy it as well. There's a link to learn more about the Honorable Judge Peck and how you can engage with him and learn more. There's also a link to order your copy of Tom O'Connor's spicy, newish book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's important eDiscovery case law decisions for June, on June 25th, now in its 5th season, as Mary said. And up next on EDRM's webinar channel tomorrow, May 29th, Down the Rabbit Hole, Navigating IP Theft Investigations. You don't want to miss this excellent discussion. The bios can be clicked and popped up to learn more about today's faculty. And then, just like Zoom, you could see the smiley face emoji, and if you click it, you'll get many more reactions that you can click on during the webinar, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And last, the Twitter bird. If you click on that, it's for social media, and you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And so our faculty, of course, anchoring, we have Doug Austin, the editor of eDiscovery Today, daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving J.D. Supra Reader's Choice Award as a top eDiscovery author and a top cybersecurity author. Doug has presented at numerous webcasts, events, and conferences, including Legal Tech New York, ILTACon, Relativity Fest, University of Florida eDiscovery Conference, the Masters Conference, and many local and regional conferences. And our very own Tom O'Connor, the director of Gulf Coast Legal Technology Center, is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters, where he's worked with firms of all sizes, including the plaintiffs in the BP litigation. He has also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his popular book, eDiscovery for the rest of us, recently updated with our trusted partner NextPoint. And then Tom also hosts with Rocky Messing the eDiscovery channel on YouTube, where they hosted our very own Holly Robinson as a guest. We're very, very excited about that. Thanks, Tom.
You bet. She was a great guest.
Absolutely. You guys are great interviewers.
Thank you.
And we have the Honorable Judge Andrew Peck. He is, again, this year, a Band 1 Chambers ranked senior counsel at DLA Piper. Judge Peck served for 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters with extensive trial experience. And at DLA, Judge Peck advises on copyright and trademark matters and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck particularly advises on innovative and efficient solutions to the challenges of information management, both within and outside the litigation context, including cross-border discovery issues. He frequently speaks at conferences as well concerning e-discovery issues. Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on e-discovery issues. And EDRM is always grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And with that, Doug, do we have some cases? Do we need to start our engines?
Very well put based on that title slide. Thanks, Mary. And welcome everybody to our May Case Law webinar on the EDRM network. We do indeed have another 6 unique cases to discuss this month. And those cases address disputes related to certification of production and discovery errors, preservation of video evidence related to the death of an incarcerated party, a cooperation dispute over counsel communications, BYOD policy and discovery from employee devices, a dispute regarding a TAR protocol, and production of device and browser cookies. Of course, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. And unlike our second case, this video has an indefinite document retention schedule. Before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling where you can check out the full ruling itself. These case law rulings are available courtesy of Minerva 26, formerly known as eDiscovery Assistant, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. Minerva 26 has over 42,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. Minerva 26 is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. In this case, the defendant made several errors in production that were attributed to its CSI vendor. Defendant acknowledged it produced around 57,000 documents in March 2024 in response to discovery requests where the ESI vendor failed to include documents from certain custodians, even though defendant had agreed to produce those custodians' documents. Defendant then produced around 1.6 million documents in October 2024 in response to discovery requests, but plaintiff discovered that most of the documents were not responsive to any discovery requests because defendant's ESI vendor had failed to apply agreed upon search terms. As a result of these errors and more minor errors, plaintiff moved for 3 forms of relief. Florida Magistrate Judge Panayota Augustine Birch denied the first one as moot after defendant provided the acquisition logs plaintiff sought after it filed the motion. Plaintiff also requested that defendant be ordered to provide output data showing the hit count from the collection, identifying the Bates number and production volume for each hit document, which would show that every document with a search term was actually produced. But Judge Augustine Birch stated, in any event, the court declines to order defendant to produce the spreadsheet. Defendant acknowledged the errors that its ESI vendor made, terminated the employment of its initial project manager, and hired a new project manager who has made or is in the process of making defendant's productions complete. Defendant has an obligation to serve a notice of completion of production when a production is complete. Defendant also has an obligation to supplement or correct its productions if it learns they are complete or incorrect. Based on the representations that defendant's counsel made in the briefing and during the hearing, the court is assured that the ESI vendor's errors will be corrected. So she denied plaintiff's second request for relief. She also denied the third request for relief of expenses and plaintiff's motion to compel certification of production and for discovery expenses overall, stating an award of expenses would be unjust in the circumstance. Plaintiff provides no evidence that the ESI vendor's errors were intentional. Based on the information before it, the court believes the errors to have been mistakes that defendant is working to correct. She did, however, grant in part plaintiff's motion to hold the defendant in contempt for failing to produce documents from certain individuals' personal devices, ordering defendant to produce all responsive non-privileged materials from those individuals' personal devices. So, Tom, failing to apply search terms before production seems like an egregious error by an ESI vendor. How can this happen, and what can clients do to help ensure their vendors don't make obvious mistakes like this?
Well, it happens more often than you'd like to see happen, and there's two main reasons. And in one case, there's an over-reliance on the part of law firms, especially if it's a big case with a lot of documents, multiple productions going on. You know, there's a lot of moving parts. They trust the vendor, especially if it's one they've used quite a bit in the past, to take care of the data, if you will. And the second problem is that if they over-rely on that, they tend to the data like dropping off their shirts at the laundry. They give it to the vendor and tell them go ahead and take care of it. In some cases I've seen, they'll even say, just go ahead and make the production. Here's some documents, you know, run this privilege log and go ahead and send it directly to the opposing counsel.
Starch or no starch, Tom?
Yeah. A lot of starch when it ends up in front of you, I suspect. You know, you just can't do that. You've got to have a good QC process where somebody at the firm is responsible for overseeing what's going on. And I think the quickest and easiest way to do that, it's something I talk about it. I talk about it a lot in the book that Mary mentioned, is checklists. You've got to have a good series of checklists that talk about what everybody's going to do, who's responsible for what. They check off when they've completed things. And somebody at the firm has got eyeballs on that process and then looks at the material before it goes out. I mean, here there was, you know, I mean, some of these errors are just, how did that even happen? Who looked at that? And I think the answer is nobody.
Yeah. Oh, sorry. Yeah, clearly nobody. Yeah, for sure.
Yeah.
Oh, yeah, and absolutely. Checklists couldn't agree more, and I think we'll touch on that here in a moment. So, Judge Peck, these obvious mistakes by the defendant's vendor, which should have been caught by the defendant's project manager, aren't the plaintiff's fault, and they undoubtedly did incur expenses as a result. So, do you agree with the decision not to provide an award of expenses?
You know, you don't know what is not reported in the decision. I don't know if the plaintiff, you know, was asking for millions of dollars in attorney's fees or something, not just, you know, something appropriate. So, but putting that aside, assuming that was not the case, obviously two things. One, the guilty party, so to speak, does get, advantages with the judge by saying, yes, we made a mistake. We are going to correct it. We are correcting it. We have corrected it. Whatever, as opposed to doubling down and disputing everything. But so, you know, that gives them a little bit of a get out of jail free card, but I don't see why the expenses that the plaintiff incurred. Yes, it wasn't intentional on the defendant's part, et cetera, but why should plaintiff be out with respect to that? So I probably would have awarded a certain amount of costs and or attorney's fees.
Yeah, it does seem a little unfair that they get stuck with that. So, Mary, Tom alluded to this. Or in a way, talking about checklists. Some parties regularly have litigation, create a litigation playbook to help ensure a defensible approach to responding to lawsuits. So, do you think that would have helped here, and what should be included in a litigation playbook?
Well, litigation playbooks that include eDiscovery have been around for a quarter of a century or so.
Right.
They're typically created as a survival mechanism for in-house eDiscovery teams at serial litigants, and they're designed to establish a core set of principles and operating tactics for the team. Philip Morris was the first time I encountered it. I just thought it was a brilliant thing. The checklists are sort of like junior litigation playbooks. If you really flesh them out, you've got the RACI charts for accountability and authority, the standard operating procedures for requesting data, sometimes with service level guarantees, how you're going to handle things. Back in the day, it was, are we going to expand the columns in a spreadsheet or not? Now it would probably be those hyperlinked files or modern attachments, text, social media, those kind of things. So I don't know about the government, though. If they have playbooks like this, I'm not sure if they're FOIA material. So I haven't encountered them in the government.
Yeah, I was wondering if that had an impact, because you would certainly expect a big city like the city of Miami Beach to have regular litigation. So you would hope they have something in place, but maybe not, given this case. So,
hey, Doug, I would just like to say thank you to Mary for not saying the playbooks have been around almost as long as Tom has.
I will next time, Tom.
We have to go a little further back. No, I'm just.
Yeah.
We'll move on to the next case, which involved the defendant's alleged failure to provide adequate medical care to a pretrial detainee after he fell down a flight of stairs and subsequently died. The only video surveillance preserved and produced by defendants was a set of clips showing the moments immediately before and after his fall. Plaintiffs sought sanctions against defendants for failing to preserve additional surveillance video of Mr. Bonilla's incarceration, which he contended would have shown the day-to-day degradation of Bonilla's medical condition. In considering defendant's duty to preserve, Oklahoma District Judge David Russell stated, plaintiff has met its burden of showing that defendant was on notice that litigation was reasonably likely following Mr. Bonilla's death. Defendants had knowledge that Mr. Bonilla's death occurred several days after he suffered a fall while in defendant's custody. Defendants obviously recognized that Mr. Bonilla's fall had some significance to his death as they investigated and retained portions of the surveillance video leading up to the fall. Defendants were also aware that in-custody deaths are the kind of incident that's likely to trigger litigation. The Grady County Criminal Justice Authority's corporate representatives conceded as much. Defendants knew or should have known that litigation was likely. Continuing, he said, defendants argued that even if there was a duty to preserve some video surveillance, the duty did not extend to any and all video evidence of Mr. Bonilla during his incarceration. That may be so, but what was preserved was insufficient. Despite recognizing the significance of the fall and being aware that inmate deaths often result in litigation, defendants retained only a short video clip showing Mr. Bonilla immediately before and after he fell. At the least, video surveillance of Mr. Bonilla's fall, medical visits, and condition the day he died were within the scope of what it should have been preserved as potentially relevant to litigation. Defendants do not genuinely dispute that they failed to take reasonable steps to preserve the video evidence or that the video surveillance cannot be restored. Further, plaintiff has more than enough extrinsic evidence to demonstrate that the video surveillance would have been favorable to his position. but he rejected sanctions under FRCP Rule 37E2, stating, although defendants should have been aware that litigation was likely and should have preserved more video than what they did, there is insufficient evidence to support a finding that anyone acted with the intent to deprive an opposing party of the video. The video appears to have been automatically overwritten, and while it may have been negligent or even grossly negligent to not preserve the evidence, the court is not able to conclude that such actions were in bad faith, such that an adverse inference instruction is warranted. Instead, he decided on sanctions as follows. Here, permitting limited evidence and argument to the jury explaining that there was additional video surveillance showing Mr. Bonilla during his detention, but defendants did not preserve the video, is an appropriate measure to cure the prejudiced plaintiff. The parties may present their positions as to the scope of evidence and argument that should be permitted on the subject at the pretrial conference. So, Judge Peck, given that the defendants preserved a short video clip of Mr. Bonilla immediately before and after he fell, but not the fall itself, doesn't that constitute intent to deprive the plaintiff of that footage? It seems more like an intentional act, given that they preserved some footage, but not all footage.
It's unclear to me whether they did or didn't preserve video of the fall itself. I think one could read the opinion as saying they had a very short period before and after the fall. Implicitly, that would include the fall. But it's also possible that where he fell was not an area with a camera. Who knows? Should they have done all this other video that would have been an easier case if Mr. Bonilla's counsel sent a preservation letter, within a very short time of the fall, assuming anyone outside the prison even knew about the fall. But having had lawsuits against state and federal prisons for what went on within them, it would not shock me that this was just incompetence, negligence, even gross negligence. I think the judge was right in saying it's suspicious, but it's not enough to make the high standard of intent to deprive. And, it may well be that the evidence that gets presented to the jury is more than sufficient to be an enforcement against the institution. Period.
Okay. Well, I guess obviously that'll be the question. So, Mary, I'll let you weigh in. I mean, even though intent to deprive wasn't found, the court did allow the plaintiff to present evidence that defendants failed to preserve other video evidence. Do you think that was an appropriate sanction?
Well, for me, it felt like an adverse inference light, without saying it's an adverse inference. But an economic sanction might influence future cases, since cost is supposedly the reason for not saving and preserving more video evidence.
Yeah, that's a good point. Because certainly, go ahead.
I was just going to say, probably not. I don't know about Oklahoma and the Grady County Law Enforcement Center, but in New York, Rikers Island, for example, which has been in the news because the court just appointed a federal monitor to take over supervision of the jail because it's so terribly understaffed, and it's not any way to run a railroad or a jail. And the money from lawsuits comes out of the city controller's budget, not the police force when it's a police case, or the prisons when it's a prison case. So, being hit with sanctions monetarily does not necessarily influence even the, commissioner level, let alone the guy who's running the video machine at the institution.
That's a great point.
Okay. Yeah. Very interesting. Yeah. That's, so I kind of really interested to say, hey, can't we do something about this? And Tom, we've covered several cases involving injuries of death of inmates where video evidence wasn't preserved, and the evidence is often deleted within a matter of weeks or so. Given the importance of the evidence, should law form incarceration facilities be required to retain video evidence longer than the average organization?
Well, I'm going to kind of take a little sidetrack here. I'm not sure why we're treating them like a regular old organization, like a business in downtown Oklahoma City. I would take the position, if I were advising these guys, I'll put on my aggressive plaintiff's hat here, that these are public records.
Mm-hmm.
And public records in the state of Oklahoma are governed by the Oklahoma Open Records Act and the Oklahoma Records Management Act. Grady County itself specifically states that records management will follow state guidelines which require public officials to ensure that records are preserved and not destroyed without proper authorization for a minimum of 3 years before they are disposed of. And so I'd argue that the whole issue of automatic overwrites and not preserving these things is a violation of the Oklahoma Open Records Act and the Records Management Act. I'm kind of surprised that nobody raised that, unless there's some sort of something's been carved out for police departments and or corrections facilities in those acts to say that they're not covered. But I would argue that this was an egregious violation of the Open Records Act as laid out, not just for the state, but specifically for Grady County. And as such, should be treated as a deliberate act.
Tom, I have a question for you because you've looked at this much more detail than I have. The Public Record Acts in Oklahoma are generally, for public records of what the legislature or executive departments or whatever are doing in terms of meetings and voting and et cetera, which can be very different than the day-to-day video that a policeman on patrol takes if they have dash cams or body-worn cameras or the cameras in a prison.
Right. Well, you're right, and that is obviously what they were originally designed for. But exceptions have been carved out specifically for dash cams and police video of various sorts, whether it's a dash cam or the body cams that officers are wearing. So I'd be aggressive about this on the part of the plaintiffs and argue that a similar exception should apply to videos in the jail. I mean, if you're going to have videos in the jail, you should preserve them. And again, I'm kind of surprised, and although I don't know anything about the firm that was involved here, that wasn't brought up, at least as a potential argument.
Yeah, I don't know. And of course, like I say, this isn't the first case we've covered that involved spoliation of video evidence in a facility like this where people are incarcerated. So this isn't just an issue in Oklahoma; it's been an issue in other places too.
No.
So
For sure. The last case we had was Washington, as I recall, state of Washington.
Yeah. I think we've had a New York one too. So I think we've had them all over. Yeah, for sure. We'll move on to the next case so we don't fall too far behind. This next case is kind of a case of he said, she said, or at least they said. In it, the parties served initial disclosures, but plaintiff's initial disclosures did not include the damage computations required by Rule 26A1A3. So she was ordered to supplement them by March 7th of this year. On that date, plaintiff's counsel apparently served further initial disclosures on defendant's counsel by email. However, defendant's counsel apparently didn't receive that email. Instead of contacting plaintiff's counsel to inquire about the status of the further initial disclosures, on March 14, defendants filed a discovery motion, which sought to compel plaintiff to provide full and complete compliance with Federal Rule of Civil Procedure 26A1A3 initial disclosures regarding damages that includes amounts calculated in compliance with the court's order and monetary sanctions against plaintiff and her counsel of record jointly and severally for violating the court's order. As California Magistrate Judge Sean Reardon noted, Within approximately half an hour of receiving the ECF notification for the discovery motion, plaintiff's counsel emailed defendant's counsel and asked, what is the meaning of the motion referenced in the ECF notification? Stated that further initial disclosures had been served consistent with the court's order, attached those further initial disclosures to the email, and threatened to move for sanctions unless defendants were to withdraw the discovery motion. Plaintiff's counsel then sent defendant's counsel a PDF version of the March 7 email that originally served the further initial disclosures. Defendant's counsel requested a native version of the March 7 email, but plaintiff's counsel did not forward that original email to defendant's counsel or attach it to a new email. So what did defendants do? They doubled down, as Judge Reardon noted. Defendants filed a joint statement that, among other things, sought to show that defendant's counsel never received the March 7 email. Defendant's portion of the joint statement also cited case law explaining that initial disclosures on computations are substantively deficient when they fail to include information about the analysis used and evidence relied upon. Judge Reardon added, at the April 24 hearing, the undersigned asked plaintiff's counsel to forward the March 7 email to the undersigned's chambers. Plaintiff's counsel did so within minutes of the hearing's conclusion. Nothing about the email suggests it is not authentic. So in denying defendant's discovery motion, Judge Reardon stated, defendants failed to meet and confer at all with plaintiff on the question of whether plaintiff had complied with the deadline set by the court's IDC order, and after being served with plaintiff's further initial disclosures on the question of the substantive adequacy of those further initial disclosures. He added, having resolved the defendant's discovery motion, the remaining issue is whether to grant plaintiff attorney's fees as a sanction for defendant's failure to meet and confer. Plaintiff seeks $66.50 in fees. Defendants will be ordered to show cause as to why such a sanction should not issue. Defendant's response to the OSC shall be filed within 14 days of the date of this order and limited to no more than 10 double-spaced pages. All righty. So, Mary, why do you think plaintiff's counsel sent defendants a PDF version of the email instead of the native email, especially given that plaintiff's counsel forwarded it to the court within minutes when asked for it?
Maybe their TIFR was broken. But I think they sent a PDF making up that they Bates labeled it. And most parties resist, producing parties resist producing native files, things like spreadsheets and PowerPoints, Word docs, and things like that. And they may not have wanted the slippery slope article or slippery slope argument to attach to them. But the only way to show that an email is sent is to look at the header. So. Maybe somebody didn't know what they were doing.
No, that could never happen. Yes, that certainly seems like that's a definite possibility. So, Tom, I'm interested in kind of what Judge Reardon did when he limited defendant's response to the OSC to no more than 10 double-spaced pages, which I still can't say. Should they consider using ChatGPT to help them write their response and keep it concise?
Only if they want to write a nice short piece of modern fiction. No, look, this isn't, the judge isn't asking for a briefing on a point of law or discuss a dispute over a statute or a prior decision. He asked for two very specific things. Tell me why you failed to meet and confer before filing your discovery motion on March 7th. And then why did you, as he said, decide to charge forward with that motion without conferring with the plaintiff, even after you received the further initial disclosures? Very, very specific issues he wants an explanation for. If they can't do that in 10 pages or less without using a piece of software, I think they're in trouble. And I think they might consider the approach that the party took in our first case here, the Penrod case of mea culpa.
Right. Yeah. Well, that would seem to they could spend the 10 pages writing, "I will not fail to meet and confer again. I will not meet and confer again."
Exactly.
It feels like they're being sent to the blackboard in order to do that. In a way. So
Perfect.
hopefully they're smart enough to, like you say, issue their mea culpa and move on. So,
Yep.
so Judge Peck, I've got to believe you probably had some parties dispute what happened between counsel during the case. If so, how did you handle those situations?
What was more prevalent was parties coming in saying that they had met and confer, and you realize that they didn't discuss anything substantively. They may have had that phone call, or more likely it was emails going back and forth, but they didn't really meet with each other. But this does remind me, trip down memory lane. The late magistrate judge Dave Waxy out of Kansas City used to say, and he and I were on many, many panels together. I got to know his shtick as well as he knew my shtick. We could, each tell the other's stories. And he would tell the story of when lawyers came in and disputed what happened at a meet and confer. He would tell them, okay, I want you to go out, redo the meet and confer, and this time videotape it. And if you can't resolve the issues, you'll give me the videotape and I'll rule. And he said he never, ever got a videotape back. He always got a report that they managed to work it out. And I told that story to one of my New Jersey colleagues at one point. And a week or two later, after she said she was going to try that, she called me back somewhat annoyed that she had just received a 2-hour videotape that she had to
yeah, that's it's funny how that's kind of an interesting, clever way to at least get the parties to cooperate. So I love that story. It's certainly we've had more than our share of cases like that where failing to meet and confer seems to be the main cause here. So we'll move on to our next case, which shows why it's a good idea to watch our case law webinars. The central issue here was whether defendant Revance had possession, custody, or control under FRCP Rule 34A over the personal devices of its employees used under the BYOD policy, thereby requiring Revance to search and produce documents from these devices. Allergan argued that the Revance employee handbook, specifically the search policy and electronic and social media sections, supported compelled searching of personal devices. Revance countered that the handbook search policy only applied to company property, and the definitions of computers explicitly includes other company-owned items, limiting its scope to company-owned devices. Allergan also cited various provisions of the BYOD policy to argue that these provisions, when read together with the handbook, gave Revance control of the employee's personal devices and allowed Revance to search them, including that the mobile device may be remotely wiped in certain instances. In response, Revance argued that the BYOD policy is not as sweeping as Allergan claims, and that permitted business activity on personal devices was limited to conducting a Revance business on the mobile device only via the user's Revance email account and Revance IT-approved email application. The parties had previously jointly moved the court to appoint a discovery special master to resolve discovery disputes, which it did. Tennessee Special Master Todd Presnell noted in a footnote that the parties' briefing indicates that Allergan chose not to issue Rule 45 subpoenas directly to the subject employees. In considering the motion to compel searching of devices, Special Master Presnell cited the case in Ray Pork antitrust litigation, among other cases, where a similar BYOD policy did not grant the employer control over text messages on personal phones because it did not explicitly assert ownership, control, or the ability to access personal text messages. We covered that case, I believe it was the beginning of last year, and earlier this year, the Charles Oakley case against MSG, where in both cases, requesting parties also issued Rule 45 subpoenas directly to the employees to get access to the text messages when their request to the producing party was denied. So regarding the handbook, Special Master Presnell stated, The special master agrees with Revance. The handbook's definition of computers includes desktops, computers, laptops, handheld devices, including but not limited to smartphones and other electronic tablets and cell phones, and other company-owned items. Regarding the BYOD policy, Special Master Presnell stated, Special Master agrees with Revance. Just as in the BYOD policy in the pork antitrust case, Revance's BYOD policy does not authorize a search of its employees' personal devices for any reason other than to inspect the device configuration to ensure compliance with all applicable Revance information security policies. The BYOD policy plainly forbidding the use of personal devices to conduct Revance business and applications other than email militates against a finding that Revance has Rule 34A control of those other applications. He also noted that he did so under both the legal rights standard and the practical ability standard. So he denied the plaintiff's motion to compel searching of the devices. So, Tom, do you think Allergan's counsel dropped the ball by not also issuing Rule 45 subpoenas to the employees, especially since there were other cases where courts ruled defendants didn't have control over BYOD devices?
Yes. I mean, there's an old saying in the IT world called RTFM, read the friggin' manual, right? And if you're going to read the employee handbook, read it all the way through. It seems like they got to the part where it said, oh, we can search computers, and that must include phones. And the judge in the last paragraph you read said the policy only allows searches for inspection of device configuration to ensure compliance with all the applicable Revance information security policies. There's nothing in there about we have the right to do anything we want with your BYOD. So yeah, I think they just misread or didn't read deep enough into the employee handbook to see exactly what was covered and what was allowed, and could have been solved easily by just serving them with subpoenas.
Yeah, and just wanted to believe what they wanted to believe, it seemed, without giving themselves that belt and suspender approach to still get to the information. So Judge Peck, when a special master gets appointed by the court, what recourse does a party have if they don't agree with his or her rulings?
Well, in federal courts, you look at Rule 53 of the Federal Rules of Civil Procedure. Factual findings and rulings of law by the special master have to be reviewed de novo, excuse me, by the appointing judge. So unlike the rules for a magistrate judge's decision being objected to before the district judge, this means it's, in essence, officially start from scratch. The judge has to decide everything anew. Practically, of course, there is a great deal of discretion to be given to the special master. That's why a special master is appointed. Just one substantive point here. One should go to the Sedona Conference website and read the Sedona commentary on possession, custody, and control, where it talks about the legal rights standard favored by the Ninth Circuit, the practical ability standard favored by the Second Circuit, and the many other circuits that use one or both tests because of no circuit decision and the district judges doing different things.
Yeah, great point. And I think the Sedona Conference just also released a guide for discovery mobile devices for public comment as well. So I'm sure, there's some considerations as a part of that. So Mary, a lot of cases like this are decided based on the BYOD policy the party has in place in their organization. So what advice do you have for our audience on best practices for creating a BYOD policy that protects their organizations?
Well, I'm just going to single out one part of the BYOD policy that served Revance very well, and that is the code of conduct includes agreement to conduct Revance business on the mobile device only via the user's email account and IT-approved email application.
Yeah.
which makes it really easy to collect it centrally, and you don't need to usually you don't need to deal with the mobile devices. So I thought they really had an artful BYOD policy.
Of course,
Yeah.
the question
go
there
ahead.
is whether the employees know to follow the policy.
Right. Yeah, well, of course, but I mean, at least they're establishing their responsibility if they don't. And obviously, one of the things that we know often happens these days is employees communicate via text as well. But that's again why I kind of think this case is interesting compared to the in Ray Pork, where the requesting parties went after the subpoenas with Rule 40, the employees with Rule 45 subpoenas to get the data that they couldn't get directly from the from the producing party in that case. So that's interesting.
And
Mike
Berman covered this on the EDRM blog in a very well cited analysis. So I'll invite you to go see that. Yeah.
Oh, yeah, great point. Yeah, and I should also mention that Kelly Twigger did as well on the Minerva 26 site. She did a case of the week on it, which was how how we found it and included it in. So yeah, interesting case. We'll move on so we can get through the last two. And the next case involves a quote, an informal discovery dispute, unquote, between the plaintiffs and defendants regarding various aspects of the defendant Express Scripts' proposed TAR implementation, specifically its use of continuous active learning model. While Express Scripts agreed to train and validate its model and disclose certain metrics, plaintiffs argued that its proposed workflow was insufficient in several key areas. So the plaintiffs sought a court-ordered TAR protocol incorporating their proposed methodology. Leaving New Jersey Magistrate Judge Ruxana Singh to resolve several areas of dispute, including training the TAR model, where acknowledging the flexibility needed in complex ESI discovery while also considering Dr. Moore R. Grossman's expert opinion against cherry picking of training examples after the initial seed set, Judge Singh directed Express Scripts to proceed with its proposal, but with the following conditions. It must use all reviewer determinations to train the TAR model for the majority of its review, and if and when it decides to limit training to only those documents reviewed for quality control, Express Scripts shall provide advance notice to plaintiffs, and the parties shall meet and confer as to whether there is consent for such limitation. And then the rest of it was what to do if there's still an impasse. For stopping criterion for TAR review, Judge Singh sided with Express Scripts, declining to adopt a preset stopping point at this stage. For the validation process, citing case law and expert recommendations, Judge Singh raised concerns that excluding QC documents from recall calculations could lead to opaque and potentially unreliable results. So Judge Singh sided with the plaintiffs on this one, ordering Express Scripts to validate their TAR model consistent with the validation process and recall calculation ordered in NRA broiler chicken, which was the validation protocol issued by Special Master Moore Grossman in 2018, including a sampling from the full TAR document universe. He also sided with Express Scripts, at least for now, in the disputes over disclosure of validation documents and validation recall target to get the workflow underway in this case. This is a case where you really need to read the case to understand more, as we can only fit so much into this slide. So Judge Peck, you once referenced in the Hiles case, Sedona Principle 6, which says that the responding party is best situated to decide how to search for and produce ESI. With that in mind, should requesting parties have a say in the process for things like training and stopping criterion for TAR?
Well, Sedona 6 does not mean that whatever the responding party wants to do is going to be accepted. It's got to be within the confines of reasonableness. So there is some ability for the requesting party to have a say. It's a question of how far should they go. One of the things that I'm a little confused about by this case is a continuous active learning model, unlike the old-fashioned TAR model that were in my cases, there is no real training set. Each document reviewed, retrains the system as you go. So I'm not 100% sure about what they were fighting about on training the TAR model. The stopping criteria and validation are the frequent targets of dispute and decisions in current TAR cases.
Yeah, agreed. Yeah, and I wondered about that myself too. So yeah, kind of interesting. Mary, are you surprised that Judge Singh ordered Express Scripts to use the validation process and recall calculation ordered in the in-ray broiler chicken case instead of their own proposed methodology?
Well, one of the things they said is having adopted plaintiff's proposal as to the validation methodology, the court will not entertain future challenges by plaintiffs to this methodology. I think they wanted to, stop the back and forth, but I think this case is one of those wonderful examples of stay in control of your own destiny and don't give it up to have somebody else decide what you're going to do.
Right. Yeah, for sure. So Tom, many people don't realize that the protocol set forth in the in-ray broiler chicken case can also be applied in cases involving exhaustive manual review. So why do you think more requesting parties don't request using a protocol like this for search and manual review process cases?
Well, two reasons. Number one, I think when we're seeing headlines about cases or webinars or live sessions about protocols, it's almost always preceded by the word TAR. A discussion about TAR protocols, discussion about TAR ESI protocols. I think, people have just come to believe subconsciously that that's what protocols deal with, is dealing with your ESI in some sort of a TAR setting or a TAR dispute. And of course, that's now been subsumed by TAR has been replaced by AI. So I think people have just been kind of conditioned to think that we're always talking about some sort of an automated process. I think the second reason, however, is that people are often reluctant to admit that they're using a manual search and review process because they think the reaction is going to be similar to admitting that they play their Engelbert Humperdinck greatest hits 8-track and tape in the car on the way home. They fear being scorned. So they don't want to bring it up. That's just my opinion.
Well, I don't see anything wrong with, maybe not on 8-track, but I don't see anything wrong with playing Engelbert Humperdinck in the car personally. But for me, I always continue to go back to, everybody seems to think that the process for search and manual review doesn't seem to require the same validation standards that the others do. We all know it can go just as sideways as any of these. So it's very interesting and kind of one of my soapbox items, which I would spend time on, but we've got to get the last case in. And let's face it, our last case has all the ingredients to merit coverage in our webinar. First, it addresses discovery of a unique form of ESI. Second, I get the opportunity to milk this topic for all the puns I can. And yes, I apologize if some of them maybe half-baked, but it is what it is. This is the latest dispute in the case involving, yes, thank you very much, involving a tracking tool known as the Metapixel, through which the defendant allegedly received the health information of millions of Facebook users. Meta's RFP 74 asked plaintiffs to produce all documents showing the cookies on plaintiffs' devices and or browsers for every device and browser plaintiffs use to access their healthcare providers' websites and patient portals, to which plaintiffs objected to producing any responsive documents. Meta contended it required the responsive documents to defend against plaintiffs' contentions that Meta was solely responsible for collection and use of plaintiffs' and class members' confidential health information for targeted advertising, that it required these documents to defend against plaintiff's contention that Meta's actions solely caused them harm, and the documents would show whether and to what extent there were variations between and among the plaintiffs regarding their acceptance or tolerance of non-Meta third-party cookies that collected and shared their health information, which would in turn inform Meta's arguments opposing class certifications. Plaintiffs' arguments for objecting included because Meta's answer did not include a defense predicated on non-Meta cookies, and because Meta never mentioned such cookies in responding to an interrogatory about its factual and legal basis for opposing class certification, RFP 74 sought discovery about matters that are not at issue. Also, RFP 74 was overly broad because it sought discovery about all cookies, and Meta should not be permitted to obtain responsive documents because it delayed seeking this discovery for over a year after receiving plaintiffs' initial objections. In beginning her analysis, California Magistrate Judge Virginia DeMarchi stated, to the extent Meta seeks documents showing all third-party cookies on plaintiffs' devices and/or browsers that collected or shared health information, such discovery is clearly relevant to plaintiffs' claims and Meta's defenses. She also noted, contrary to plaintiff's suggestion, the court is not persuaded that Meta was required to plead as an affirmative defense that it is not solely responsible for or did not cause the harm complained of, or that it was required to mention non-Meta cookies in its answer as a condition of developing evidence negating the essential elements of plaintiff's claims. In addition, the discovery Meta seeks also appears to be relevant to the arguments it expects to make in opposing class certification. While acknowledging that the scope of RFP 74 exceeds the scope of relevant discovery because it encompasses all cookies, regardless of whether they are capable of collecting and sharing plaintiffs' health information, Judge DeMarchi ordered plaintiffs to produce documents sufficient to show all third-party cookies on plaintiffs' relevant devices and/or browsers capable of collecting or sharing health information. However, she also ordered, by April 30th, 2025, Meta shall identify objective criteria plaintiffs may use to facilitate the identification of relevant responsive cookies. So for the plaintiffs, that's the way the cookie crumbles. So Mary, many of us have hundreds, if not thousands, of cookies on our devices installed from all the websites we visit. So how can the plaintiffs be expected to proportionally figure out which cookies, if any, are collecting health information? Wouldn't it just be easier to produce them all and force Meta to sort them out?
Well, it'd be easier for that, but then you have to explain what all those cookies are for. And plus, you let out cookies from financial institutions, and then what about the websites that plaintiffs are visiting that they might not want brought into court when their testimony is being impeached and things of that nature? No, I wouldn't just give over all the cookies. Not even to you, Doug.
No, not that I deserve them. But yeah, this seems like a really challenging one. And certainly, Tom, cookies are not a common form of VSI to be included in discovery. And I'm sure you've had some cases that dealt with uncommon forms of VSI. So what recommendations do you have for our audience on how to address discovery of uncommon forms of VSI in their cases?
Well, I think Judge DeMarchi covered the two big points that you should address in her order. The first one you mentioned here in one of the paragraphs where she said, all the third-party cookies that were collected or shared, same kind of data that's at issue in this case. This discovery is clearly relevant to plaintiff's claims and Meta's defenses. So if you've got some sort of new technology, whether it's cookies or brownies or pound cake, whatever, make sure that you make a showing that it's relevant to a claim or defense, so that it's not an obscure technical reference. You got to bring it down to the facts in the case. And then later in her order, she said the parties' lack of cooperation regarding this document request is troubling. The court expects that with some effort, the parties could have at least narrowed the scope of the production responsive to the request, end quote. So identify what we're talking about and how it's relevant to a claim or defense, and then meet and confer. Basic Sedona principles of cooperation, right? Get in there and talk about this. Don't just throw this big mess in the judge's lap to be sorted out. Make some sort of a good faith effort to resolve it. And as the judge said, you would expect that if you do that, you could at least narrow the scope of the argument.
Well, yeah, that's a great point. I didn't have enough room to include that on the slide, but Judge DeMarchi did call the parties to task that they could have negotiated this down a bit. And again, yes, yet another case where they could have met and conferred more to get, before they bring it to the court. So Judge Peck, do you think that Judge DeMarchi should have given more consideration to plaintiff's contention that Meta delayed seeking this discovery for over a year after receiving plaintiff's initial objections? Or does the importance of this evidence outweigh potential procedural delays?
Yes and yes. There was obviously, this is an MDL. There was a lot going on in the year between the objections and when this actually came before the court. And what Judge DeMarchi had to do was weigh the importance of the evidence, which she clearly found was very important, against any delay factor. And she dealt with the delay in a different way, which is, if you look at the dates, this is a decision on April 24th. She ordered Meta to come up with the objective criterion to identify the relevant cookies within less than a week. It was, I think, to the 30th of April. This was not going to be one where she was going to let this go on for months and months and possibly destroy the discovery cutoff date. Just picking up on the cooperation issue, it's interesting, this is one where the parties could have considered some sort of sampling approach of limiting it to a few plaintiffs and their cookies as opposed to every plaintiff's cookies in the class or potential class. Things like that. When you get to weird or at least uncommon forms of ESI, that sometimes is a very effective way of dealing with it. Too late at this point, but that's where the cooperation that Tom was calling out could have solved things.
Well, personally, I love sampling cookies, so it is a shame that that wasn't considered. Yes, very interesting.
You had your glass of milk.
Yeah, I've filled it enough.
Warm milk. That's right.
Point. Yes.
Right.
So we are a little past time, but we do have a couple of late questions while I show the contacts page here. And as Kaylee mentioned at the outset, our next webinar is Wednesday, June 25th, and maybe our picnic basket will have more cookies. You never know. But before we go out, I'm going to, for those who want to, I'm going to stay in and touch on a couple of the comments. One, back to the discussion of meet and confer from one of the earlier cases. First lesson of motions practice: don't show all your cards in the meet and confer. So obviously that's an interesting comment there, and I'm sure that's what a lot of folks are doing. Any thoughts? Any response to that one?
I'm hoping that was a facetious comment.
Yeah, we'll see indeed. And then one that from the BYOD case, on the BYOD topic, any comments from the panel on the use of on-device proxy where a user consents to corporate monitoring, such as via a data loss prevention product? These work by forwarding all web traffic to a central server that inspects it with a DLP tool, and they frequently catch false positives or employee data from the personal device. Would the DLP data be considered discoverable if the device owner was a named party? Thoughts on that?
Well, I think the key there is going to focus around the comment that where a user consents. Was it a knowledgeable consent? Did they understand what they were consenting to? Does it open the door to all of that being monitored?
Mm-hmm. Yeah, absolutely. And I think that's one that's an interesting one I haven't seen covered. So have to dive into that one a bit. But certainly a great question. And I think we're continuing to see cases involving BYOD and
Yep.
So with that, thanks for the questions and the comments, folks. And with that, I will turn it back over to, I'll say thanks to Mary Tom and Judge Peck for their terrific insights. And now I'll turn it back over to you, Mary.
Thanks, Doug. And EDRM thanks you, Tom O, and the Honorable Judge Peck for this insightful presentation. Our thanks to the EDRM community for your kind attention. And if you really loved it, show Judge Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thank you.
Bye-bye.